Fellow board members, ladies and gentlemen, Mr. Andrews, we have a couple of letters that I'd like to read, for the people that we've received through counsel from the district attorney's office. So they're quite lengthy, and I would appreciate your indulgence while I read through them. First one is dated December 4th, 2009, and it's addressed to Lauren Goldberg, Esquire of Copeland and Page, regarding the Wareham Board of Selectmen executive session of June 2nd, 2009 open meeting law. Dear Attorney Goldberg, this office has reviewed the information that you provided in the above-named open meeting law investigation. This office finds the Wareham Board of Selectmen, the board, violated the open meeting law in its discussions in executive sessions of May 26th and June 2nd, 2009, by discussing matters that exceeded the scope of the stated purpose, number 5, the investigation of charges of criminal misconduct or the filing of criminal complaints. General Law, Chapter 39, Section 23B, number 5. Mark Gifford requested this investigation because the board discussed his reputation in executive session on June 2nd, 2009, without providing him with the necessary rights under the open meeting law, General Law, Chapter 39, Section 23B, number 1. According to both the board and Mr. Gifford, the board posted a notice of a meeting scheduled for June 2nd at 6 p.m. with an incorporated agenda listed in executive session under purpose number 3. To discuss litigation, General Law, Chapter 39, Section 23B, number 3. The board has satisfied its burden to show that litigation was indeed discussed at the executive session. That litigation is ongoing, and any minutes relating to the executive session discussion of the ongoing litigation may be withheld from public inspection until the litigation is completed. However, the board's June 2nd open session minutes do not contain any reference to an open session prior to the executive session. The open meeting law requires that every governmental body convene first in an open session for which notice has been given and then vote to enter executive session. This office reminds the board of its obligations to begin every meeting in an open session, even when the board intends only to hold discussions in executive session, as required by the law, General Law, Chapter 39, Section 23B. The publicly available open session minutes must also reflect the purpose for the executive session announced in the open and vote of each member during the required roll call vote on whether to enter that executive session. The June 2nd executive session minutes, now in parentheses, though not the open session minutes, end of parentheses, reflect a recorded roll call vote to enter executive session under purpose number 5. It was permissible for the board to vote for and announce a second executive session purpose on June 2nd if done at properly posted open session. Purpose number 5 permits a governmental body to enter executive session, and then it says T, to investigate charges of criminal misconduct or to discuss the filing of criminal complaints. General Law, Chapter 39, Section 23B, number 5. This purpose did not appear on the agenda. There is no requirement for posting an agenda in the current version of the open meeting law statute. General Law, Chapter 39, 2 sections, 23A and 23B. If a governmental body posts an agenda, nothing in the statute prevents the body from discussing additional business outside the items listed in the agenda, as long as the additional purpose was properly announced in open session. Thus, there was no error in the posting of June 2nd's meeting. Part of the June 2nd executive session was broadcast to the public without the knowledge of the board. Because of this broadcast, the public learned that the board had undertaken a broad investigation of the town computers, a computer audit. As a result of the broadcast, Mr. Gifford later learned that one selectman made complaints about Mr. Gifford's reputation during the discussion in the June 2nd executive session. Mr. Gifford contacted this office because he was not afforded any advance notice that the board would engage in discussions about him. General Law, Chapter 39, Section 23B, number 1, through number 2. The board takes the position that these comments were not a discussion about Mr. Gifford because they were the comments of one individual selectman. This office does not accept the board's interpretation of the comments about Mr. Gifford. From the board's response to this investigation, it is apparent that the comments were made in the normal course of the discussion in executive session and represented one selectman's viewpoint during that discussion. Therefore, that statement is not exempt from scrutiny under the open meeting law simply because it was only voiced by one member. Purpose number 5 allows a governmental body to discuss investigations of potential criminal misconduct. The ensuing discussion must in fact be limited to an investigation of concerns about possible criminal conduct. The board is required to demonstrate that the executive session was in fact used to address such a concern rather than some other unstated purpose. General Law, Chapter 39, Section 23B, in parentheses, in any lawsuit, the governmental body has burden of proof to show that its actions complied with the open meeting law. End of parentheses. District Attorney for the Northwestern District versus the Board of Selectmen of Sunderland, 11 Mass Appellate Court, 663-664 of 1981. Collective bargaining purpose was deemed a pretext when no employees were present for purposes of bargaining. Puglisi versus School Committee of Whitman, 11 Mass Appellate Court, 142, 144 through 145, 1981. Executive session purpose to discuss reputation of superintendent was deemed to be a sham to hold a private discussion on firing of a school employee. The board has alleged that it had information giving rise to a concern that the town computers were used to commit a crime, namely criminal harassment or a civil rights violation. And it has a footnote number 1, which I'd like to read first. Number 1, the board suggests that another unrelated potential crime also justified an investigation under purpose number 5, but has not provided sufficient factual basis to support a reasonable or good faith belief that such a crime was occurring or had occurred. The complainant in the matter had reported the incident to the FBI and to this office. Neither the report to the FBI nor to this office contained an allegation about the use of town computers. On July 22, 2009, this office determined that the allegation by the complainant, though insulting, did not rise to the level of a crime. Even assuming that the board had a plausible belief that a crime had occurred, the board went beyond the scope of the executive session purpose on June 2nd, as shown below, on May 26th as well. Even if some discussion in executive session was justified to consider what to do about a possibility that town computers were being used to commit a violation of a person's civil rights, the executive discussion here quickly went beyond that limited topic. There is no support for the proposition that the comments about Mr. Gifford, his co-worker, and his department were connected to the allegations by the complainant or to any criminal investigation generally. The board admitted that the discussion of Mr. Gifford was not relevant to the criminal investigation under purpose number 5, calling them isolated remarks made by one official. Board members must strictly confine their executive session discussions to the cited purpose. District Attorney for the Northwestern District versus Board of Selectmen of Sunderland, 11 Mass Appellate Court, number 664. The minutes of the executive session that were provided to this office demonstrate that the board did not limit its session discussions to the complaint allegations of a potential crime or criminal misconduct generally. The discussions here addressed a more generalized town-wide audit of computer use, as well as deficiencies and new proposals for town computer usage unrelated to criminal activity. Puglisi versus School Committee of Whitman, Mass Appellate Court 144 to 145, in parentheses, though the committee cited a valid purpose, the committee was not permitted to discuss different subject and purpose in executive session.